Person at the jail, what is your name?
You don't know my name?
Yes,
This hearing begins in immediate chaos. The judge simply asks the defendant to confirm his name, a routine formality, yet the defendant spirals into paranoia, claiming the judge is under investigation and accusing officials of conspiracies and assassination attempts. His responses jump between delusions, threats, and grandiose declarations. The judge tries to maintain structure, but every attempt at basic communication collapses under the defendant's escalating instability and refusal to engage reality.
Yes, what is your name?
You don't know my name. Who are you?
I'm Judge Wiggins. I'm the judge of the 84th District Court. I have a name on paper. I just want to confirm it's you. So who is your name?
You asked me what is my name.
Yes, what is your name?
You're under investigation.
That's what, I'm sorry?
You're under investigation for saying what is my name. You don't know who I am since I've been here?
Are you Yuri Alexikov?
That is he.
That is you?
That is me, yeah. That is he, that's me. This is the name I was given.
Were somebody from the defender's office able to meet with him today?
Briefly, he declined my help, but I would like to raise competency issues nonetheless.
I did not
sir,
I just asked for copy machines, I asked him to grab camera footages of body movements from these, see how to inspect body language, see if there's any kind of whispering while I was in that jail cell talking, like for 24 hours straight. If they did not record my threats I was making during that stay at the jail cell, if they didn't record, he said, I'm going to check systems in other copy machines, if it's how it was been made and built in other jails, if it's capable of recording, and I'll see who manufactures these copy machines. If it's erased from that capability to not record, if it's been erased, you guys will all be charged for tampering with evidence. All
right. Well, I have a process I have to go through, so let me get through that first. So I have a complaint that alleges that on or about October 8th, 2025, in the village of Buckley in Wexford County, it is alleged that you committed the offense of police officer assault, resist, and obstruct. That is a felony punishable by up to 2 years in prison and/or a fine of $2,000, and consecutive sentencing may be imposed if it happened in a place of confinement. Additionally, you're charged with...
Guys, Lord. Investigation, my friend. Who you are, we're going to put you under investigation, honorable. You're not an honorable judge anymore. Corey Wiggins, you're under investigation. Who you are, who we have contact with it. You're government employees, so you're within the terrorist organization. We're going to find out because there's corruption involved. There's attempted assassination on me. I was poisoned. I have the right to defend myself. Any kind of Russia to be notified, any terroristic arrest. I said 7 months ago, you guys arrested terrorists. I said Russia has to be notified because I was poisoned. Any food given to me, I count America as there's terrorists. For corruption, you guys want to kill. So I want Russia to be notified, send a plane. You say, you already know they can just get the copy machines, get them and follow the orders. Follow the security I built inside me to combat terrorism and corruption.
By this point, the defendant's delusions intensify dramatically. He insists he has a right to threaten officials because he believes he was poisoned, demands Russia be contacted before any charges, and labels the court a terrorist organization. The judge calmly continues outlining the charges and habitual offender enhancements, but the defendant erupts repeatedly, shouting over the proceedings. It's a moment where the clash between legal procedure and severe mental deterioration is unmistakable.
And corruption. Thank you very much. And we will stand for the law. We will not bow down to filth and corruption in the system. We will not. We'll take action. We the people will take action. You're all, this county's under investigation for attacking, for accusing me, Judge. You're under investigation. You understand? For threatening October 7th.
Count number 2, you're charged with malicious destruction of fire of police property.
We're gonna monitor you. We're gonna see what you have because there was attempted assassination on me. All right? You better shut your mouth and sit. There's nobody.
That is a felony punishable by up to 4 years in prison and/or a fine of $5,000.
I have the right to threaten. I was poisoned. I said a long time ago. Authorize a plane to land. I was poisoned. I have the right to defend myself to get out of this lane for terrorism. I have the right. Do you understand that, Judge?
Additionally, you've been charged as a
The
fourth.
contrast in tone is striking. After the previous outburst, the court shifts to a routine misdemeanor plea with a different defendant, calm, direct, and straightforward. The judge methodically confirms rights, voluntariness, and the factual basis for the plea. The defendant answers appropriately, signs the advisement, and proceeds without issue. Compared to the chaos earlier, this segment highlights how standard the process is when a defendant is coherent, cooperative, and grounded in reality.
Charged as a fourth habitual offender.
Listen, I don't care about your charges. I'm gonna, Judge, if you insult me one more time, do it. Tell me you're gonna charge me. Contact Russia before you charge me. You're not allowed to charge me prior to any terrorist arrest. Russia to be notified. Did you notify Russia? You're under
That
arrest.
makes each of those charges
You're
punishable by up to
under
15
arrest.
years in prison.
Sit. I don't care about your charges. Sit, you terrorist, corrupt terrorist. Sit.
On felony
Okay.
complaints, you have certain rights. You had the right to remain silent.
break that
All right,
face mask.
corrections, you can
I'll
remove
break
him.
your
We'll try
face.
this. We'll try this at a different time. I don't want to
I'll break-
endanger yourself.
Yes, Your Honor.
Thank you.
You're not going to accuse me of any charges. You're not going to have victory in me.
Raise your hand. Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Don Lee.
This court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. You understand that, sir?
Yes, sir.
And understanding all that, still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand by pleading guilty, you'll not have a trial of any kind, but
Yes.
you cited an advice of rights form, correct?
Yes.
Any question regarding those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Anybody promise you anything other than what's stated here today on the record to get you
No.
to plea? Anybody threaten you or coerce you?
No.
Doing this voluntarily
Yes.
of your own free will because you believe that you are indeed guilty?
Yes.
On the date of February 10th, 2024, Michigan Road near Moon Road in Pittsfield Township, Washington County, State of Michigan, did you have custody or control of a motor vehicle?
Yes.
Did you allow someone who is otherwise ineligible to operate that motor vehicle?
Yes.
Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court
Sir.
will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Anything you want to say before I impose sentence?
Just very briefly, Your Honor, Mr. Lee is asking that the court consider sentencing him to time served. I do acknowledge he wasn't arraigned on this case until September 19th and only has 9 days credit, albeit he was not being held on this case. Outside of that, I just leave it in the court's discretion.
Anything you want to say, Mr. Lee?
And I just wanted to get this over with and keep him going.
You come back on the other thing tomorrow. Is it tomorrow?
He's up on the 8th.
On the 8th.
For exam, Your Honor.
Just trying to recall, when I put you into custody, did we set an exam? Is that what we
Yes.
did?
Exam is on the 8th.
Before me?
No, it's before Judge Burke.
Okay. All right, I'll take a look at that because all right.
I think I have the file out, Your Honor. Did the court have a question I could help with?
Well, I put him into custody, but I know I told him I was going to take a look at that on the remand into custody on it because it came as a result of a police report regarding something else happening.
Yes, it was because there is a new case that is coming down the pipe, to which Ms. Blanche said that the warrant was going to be authorized that day, I believe. Mr. Lee advises, and I don't see anything to contradict that, he hasn't been arraigned on that new charge yet, however, but the 2 ones that he was in front of Your Honor for last week for PCC are set for exam, both cases in front of Judge Burke on October 8th. He's represented by Sam Bernstein in one and the public defenders in the other.
Okay, so my question becomes all right. That's right. That refreshes my memory. Where's that other case? Because the thing, I'm not asking.
Okay,
You don't know.
I know I ain't been arraigned on it.
No, I know, but I'm trying because
So you're.
I don't know. Did I change his bond on? I did change his bond on that. He was supposed to then be arraigned on the other case, but that case was supposed to get. There was supposed to be a timing on that case to get down. So I remanded him. He was going to be held on these cases, on the ones that are set for exam. And then that other case was going to come down, expected that he might be in on that case. But if that case hasn't come down, I'm not going to be very happy right now.
Yes, to my understanding, Your Honor, he has not been arraigned on that new case, but the two cases that are already set for exam in front of Judge Burke, currently his bond is $15,000 on each of those cases.
Correct. I get that. What?
You raised it was a PI bond and you raised it up.
I put it up because of the representation of these other cases, but those other cases were supposed. What's the status of that other case?
Your Honor, Ashley Lottie, for the people on behalf of talking about these other matters. So if I'm reading this correctly, other cases was a resisting and obstructing case that was supposed to be coming down. Is that, Ms. Page, is that correct?
I don't think that was, it was involving a car accident and some other stuff.
I don't know the exact charges that were to be authorized, but I know the incident date was before the ones that are currently set for exam.
Right.
That being said,
I know.
Yeah.
Listen, where is that case? Because my problem here is that, and Mr. Lee is certainly not always the most cooperative person in the world, and he knows that. But he got remanded because his other case was coming down.
Correct.
And so I'm trying to, and I think there was a representation that it had been signed off or it was someplace, and the expectation was that case was going to get sworn out. While in custody, he'd be arraigned. And then there would be, based upon the facts of that case, a bond set that was likely or may have, I can't say for sure, may have kept him in custody, which is why I did what I did.
That was my understanding, Your Honor.
I just need a little bit more information.
Go look.
So I want to understand, Mr. Lee was last before the court for PCCs. The court is saying on the 26th or the 18th.
I think it was a week ago, wasn't it? I think it was
The 20.
I think it was the 26th. He was before me.
I have some help helping right now. So the new case, which does appear to be related to fleeing and eluding charges, dated incident 8/29/9/20 to 9/2. It appears that case was authorized, signed by my office on 9/26. And I don't see.
That's what was indicated to the court on the record, that it was signed off on 9/26. But then there was a representation that it was going to get sworn to. It was signed off by your office. I think that's what was represented to me. It was going to get sworn to so that Mr. Lee could be arraigned on it.
My understanding is that Magistrate Fink signed that case on September 30th. It is likely,
well, then why hasn't he been arraigned?
I'm not sure, Your Honor. It may be in a stack of things that are waiting to be entered. That's been happening.
Oh,
I don't.
no, that will not happen. Miss.
Can you tell me what the jurisdiction is? Yes. It's not.
It's
not
Ypsilanti City. It's Ypsilanti City.
It's a city case?
No, I showed us
It's a
14B.
sheriff's office. It's a sheriff's office arrest that occurred in Ypsilanti City.
I show with the 14B.
Okay, so it's on the line.
I have a police officer.
Oh, really?
Yes, that helps.
So, whoa. Is that what the log notes indicate?
Yes,
So there are no charges?
correct. It says court does not find probable cause.
Okay.
Well,
Just hold. That's what it says?
Yes.
So there is no case?
Can I confirm the police report number for that? Yeah, I have it up. Washtenaw County Sheriff's Department report number 24-67821. I have 68821. I don't know if that's a typo, but.
And?
I'm checking with Melanie.
Yes, and while you're checking with them, have me bring them Mr. Lee's other 2 cases that are set for the 8th. Immediately.